Section 702 of the Foreign Intelligence Surveillance Act (FISA) is a powerful surveillance tool. It allows the government to collect communications between foreign targets outside the U.S. But this tool has been repeatedly misused by the FBI to spy on Americans. This violates their own standards and privacy rights. The FBI has searched the Section 702 database for information on Americans linked to the January 6 insurrection or arrested during Black Lives Matter protests. These searches had no foreign intelligence purpose or evidence of a crime. They were fishing expeditions to find dirt on domestic suspects. For example, an analyst conducted 13 searches of people who were suspected of participating in the riot to see whether they had any foreign ties. The Justice Department later determined that it did not meet the standard required for a search. The FBI also searched for information on more than 100 people arrested amid the racial justice protests in June. The FBI said it expected the searches to yield foreign intelligence, but the reasoning is mostly redacted. These are just some of the examples of how the FBI broke the law hundreds of thousands of times. The FBI claims that most of the violations were because of confusion among workers and that it has taken corrective measures. But these excuses are not convincing. The FBI has shown that it cannot be trusted to wield this sort of power responsibly. Section 702 is supposed to be limited to surveillance of foreign nationals, as FISA's name suggests. But the truth is that this pool of intelligence data is too large and powerful to be contained. It is nothing short of a loaded gun aimed at the heart of democracy, a lawless digital dragnet systematically abused by those who swore to uphold the law. Section 702 is an affront to the Constitution. It allows the collection of nearly every email and phone call. It has little to no evidence that it is useful in protecting us from threats abroad, and growing evidence that it is being misused here at home. We simply need to end Section 702 and this sort of bulk surveillance. One of the most shocking revelations of the Mueller investigation into Russian interference in the 2016 election was how the FBI fabricated evidence and lied to the FISA court to obtain an illegal warrant to spy on Carter Page, a former Trump campaign affiliate, based on the unverified Steele dossier. The Steele dossier was a collection of memos written by a former British spy named Christopher Steele, who was hired by a research firm called Fusion GPS, which in turn was hired by the Hillary Clinton campaign and the Democratic National Committee. The dossier contained salacious and uncorroborated allegations about Trump's ties to Russia, including a claim that he was secretly filmed with prostitutes in a Moscow hotel room. The FBI used the dossier as the main source of evidence to justify its surveillance of Carter Page, who had previously worked as an energy consultant in Russia and had contacts with Russian officials. The FBI claimed that Page was a foreign agent who was coordinating with the Kremlin to help Trump win the election. However, the FBI knew that the dossier was unreliable and had serious flaws. For example, the FBI learned that Steele's primary subsource had contradicted many of the claims in the dossier and had described them as rumor and speculation. The FBI also learned that Steele had a political bias against Trump and had expressed his desire to stop him from becoming president. Despite these red flags, the FBI did not inform the FISA court of these problems and continued to rely on the dossier as credible evidence. The FBI also omitted or distorted other relevant information that would have undermined its case against Page. For instance, the FBI altered an email from another U.S. intelligence agency that stated that Page had been a source for them, which would have explained his contacts with Russians.